defensive force, you have to be facing a deadly force threat. A threat capable of causing you death or serious bodily injury. That legal standard remains the same. So it's very straightforward. It's very simple, really. What's complicated is the real world, however. What constitutes a threat that could readily cause death or serious bodily injury can change depending on the circumstances. So someone who's an 80-year-old victim of a physical assault is obviously at much greater risk of serious injury than would be a healthy, otherwise fit 20-year-old who's the victim of the otherwise identical physical assault. Somebody who's on prescribed blood thinners, for example, is at much greater risk of a blow to the head than someone who's, again, a healthy, otherwise fit 20-year-old victim of that exact same punch to the head. So what would not be the same punch to the head, what would not be a deadly force attack on a healthy 20-year-old could very well be a deadly force attack upon that person on the blood thinners. So the legal standard hasn't changed. The legal standard is still you have to have been facing a deadly force threat before you can use deadly defensive force. But what qualifies as a deadly force threat can change depending on your particular circumstances. The same is true in all other characteristics around the self-defense scenario. So if your attacker is much larger than you, has an exceptional fighting ability that you don't have, is more numerous than you, but certainly your physical abilities or disabilities, whether they're permanent or transient. So they may be disabilities that you're going to have the rest of your life, they never go away, or they might be disabilities that are the consequence of, as here, a surgery, that theoretically those disabilities may go away. You may regain the state of health and fitness that you had before, hopefully, right? That's what we all hope after surgery. But whatever the impact on you, if it's made you more vulnerable to injury and or made it more difficult for you to defend yourself to the point that what might not have been a deadly force threat under normal circumstances is now capable of causing you death or serious bodily injury, not because the threat has become increased, but because you are in a greater state of vulnerability, yes, now you're facing a deadly force threat, a threat readily capable of causing death or serious bodily injury. And in that circumstance, you'd be privileged to use deadly defensive force. Now, does it matter that the person punching you in the head doesn't know you're on blood thinners? They don't think they're causing you a deadly force injury, arguably, they would argue. No, it doesn't matter. What matters in your decision-making, your perceptions, decisions, actions, and self-defense is your reasonable perceptions of events. So it's what you know that controls. So if you know that punch can kill you because of your unique vulnerability, because you're on these prescribed blood thinners, well, then you know it's a deadly force threat, and therefore you can use deadly force to defend yourself, even if the other party had no idea they were causing you a deadly force threat. That's on them. Okay, and the last question we had for today comes from Scott M. I guess he asked on a previous show and I didn't get to it. He's asking about what are called excited utterances or admission against interest. These are exceptions to what's called the hearsay rule, folks. So the hearsay rule, the technical definition of what qualifies as hearsay is a statement, an out-of-court statement offered in court to prove the truth of the statement. And typically, it's something that most of us would recognize as gossip. Someone is testifying in court about something that somebody else said, and that other person's not in court to recount that statement themselves. That's hearsay, and hearsay is generally inadmissible as evidence, and there's good reasons for that. The normal kind of testimony we want in court is you have a witness who has personal knowledge of some event and are testifying in front of the jury about their personal knowledge of that event. The reason we like that kind of evidence is because it gives us an opportunity to question that witness, to cross-examine that witness. It gives an opportunity to impeach that witness, say they have a criminal record or a demonstrable history of lying, or some self-interest or bias or other motive not to tell the truth. It gives the jury an opportunity to hear and see that witness testify in person. That's why the Constitution recognizes our right to face our accuser in court, so the jury can make an assessment of that person's apparent credibility on the stand and